unfortunately, it's just not going to work out. So, Jeff, what's the best way for an employer to communicate that to the individual?
Say, sorry, it's not going to work out. And,
Easy enough.
invoke your right to reject and don't give a reason for it.
All right, everyone. We're back again with the Labor Thoughts podcast, and for the astute viewers, listeners, we have a guest with us today. He's definitely no stranger to being here, and he most likely won't be a stranger in the future. But we have Jeff here with us today. Jeff, if you want to just say hello real quick. And
Sure, Ryan. Hello, everyone. Glad to be here again. Happy to help out and look forward to it.
All right. Well, we've got Jeff joining us today because the topic, for those of you that clicked into this, is you're hired. And no, this isn't Jeff's interview to bring me onto the labor relations team. This is a topic that kind of comes up a lot. It doesn't really matter what we're talking about. We always tend to find ourselves discussing that invisible line that seems to exist either in the legal world of employment or even in the union world of employment of between an applicant and employee. At what point do you kind of cross that barrier? We're going to talk a little bit about that today, but we're going to lean on Jeff's expertise to hopefully answer that. I guess, spoiler alert, I don't mean to cut in on Jeff too much, but that line's not really as clear as we'd all hope for it to be. So Jeff, from a legal perspective, what is the difference between an applicant and an employee?
I think all things being equal, in other words, there's not contractual language that alters the common law definition. An applicant would be someone who is seeking employment, right, and going through whatever processes are necessary to interview, apply for a job, and go through whatever other pre-employment obligations an employer or a situation would call for. And then an employee would be someone who has ideally accepted an offer of employment and actually started to do work that would require the payment of wages, right? So if you're looking for when the clock starts, it would be the first minute of work that would require an employer under the law to pay wages.
Yeah, it's and that seems very definitive, very succinct. The first minute they start performing work, but I think that's where it starts to get muddy in our agreements. For those of you out there that have dealt with these grievances or dealt with the specific contract language that Jeff alluded to, it can be difficult to determine what that first minute of work is. We have agreement language out there that, like, let's take show up pay, for instance. An employer contacts the local union, they send somebody out. Our position is they're still an applicant at that point. They have to go through the hiring process, if you will, with the employer. But whenever you throw something in the mix like show up pay, I call the local union, they send Jeff out. And if we decide we're not going to employ Jeff, there may be contractual language that says we owe Jeff 2 hours of pay. So, is Jeff an employee at that point? Does that make him an employee of the company, or is he an applicant? And then you get into that interesting discussion, and we're not going to break all that apart today because there's obviously other tests that go in there, but that's just an example of how that type of language can become problematic just from what Jeff just said there, because has that individual performed work at that point? Are they considered an employee or are they an applicant? So it's always a fun one to work through.
Yeah, and the other concerns that come to mind is that, depending on whether or not you're looking at state law or federal law, there are laws that are applicable only to applicants, and obviously there are laws that are applicable only to employees. And so I think that's where the rub comes in, where, if you're actually paying for waiting time or show up time, and then something happens in that time period that would implicate the employer as a true employer of that quote unquote employee, there could be other ramifications that we would rather not deal with. So, I think making sure that you don't have language in your contract that confuses applicant and employee is important.
Yeah, that's a big one. And just if you're ever interested in having that discussion, our labor relations team, along with the field staff, have more than a handful of presentations where we can go through that, and we would love to dive into that discussion with you, help you identify language that can create that issue there, because what Jeff is talking about is, I guess, unintended liability. Yeah, it's that person that you thought was an applicant, but now because of this contractual term, you've compensated them in some way. And I think maybe what you're talking about, let's say they get into a car accident or something like that.
Sure.
The employer could incur liability from it. But Jeff, you mentioned some kind of legal protections and the differences between an applicant and an employee. So what are some of the key protections that an applicant has from a legal standpoint?
Well, the first thing that comes to mind is that applicants in the pre-offer, the pre-conditional offer stage, can only be asked certain questions. There are things like drug testing depending on the state, credit runs depending on the state law, and fit for duty type of tests that applicants are protected from in the first instance. And you've got to get to sort of step 2, where you provide, again, depending on state law, a conditional offer that allows you to do more in-depth probing of that potential hire. So, again, we keep going back to this line of applicant versus employee. We want to be careful that your interview process and your intake process, your recruitment process, is tiered properly so that you don't get out in front of your skis with someone and then end up not even making them a conditional offer, and you've already done some things that maybe the law wouldn't allow you to do.
What would be the impact on an employer if they, like to use your term, got ahead of their skis there, and they kind of crossed that line? They haven't made that conditional offer, but they've started to ask things as if they had.
Mm-hmm. So, if the potential employee doesn't get the job, then, you would open yourself up to a lawsuit for, either negligent or intentional discrimination or violation of whatever state, law. Let's say you conditional offer to someone and you run them through a series of physical fitness tests or something like that, and the state law says you can't do that until they get a conditional offer, and they come back for that second round of, quote unquote testing, and you disqualify someone because they can't lift 50 pounds or, run a mile or whatever the test would be. Then you can find yourself in an employment discrimination or an employment, statute violation situation where, someone would have a cause of action against you for not hiring them.
I was always curious why the fit for duty test for labor relations was we had to have like under a 10-minute mile. So I haven't figured that one out yet.
I'm trying to get that lowered, but yeah.
Oh yeah, we need us faster.
Yeah, right? It's convention, running around those convention halls.
But jumping back to the serious, getting into that conditional offer, what does a conditional offer of employment look like to you?
Well, again, it would be ideally, let's back up a little bit. So you should have a process for recruitment and interviewing and intake and things like that. You should make that process as objective as you can. You should be asking the same questions of all candidates, all applicants. and you get to a certain point in time where minimum qualifications are met. The initial intake is a success from your process's standpoint, and you're ready to make a conditional offer. Again, which depending on state law and any contractual obligations, would afford you the right to go to the next step with that candidate and get into some areas that you wouldn't be able to do at the interview stage, at the pre-conditional offer stage. So again, you should be training your recruitment folks, your intake folks, in what they can do in those stages and the questions that they can ask, at the different stages, because they're a little bit different, and again, depending on state law.
Yeah. Yeah, that's the major asterisk we kind of put on everything we say. You always have to check state law. Looking at you, California.
Right.
So always check that. So the employer's done everything right, and they're going to make that conditional offer. Does that need to be in writing? How would you make said offer to an employee or applicant? Sorry, see, I messed it up.
Well, I mean, I don't know of a law that says that it has to be in writing. I think best practice is that it's in writing, and I think your policy should dictate that. Here are your expectations upon applying for an employment. You go through this process, and at the end, you'll get a written conditional offer, which one would think the candidate would accept in writing, and then again, so there's no dispute over, well, I didn't understand that was what was going on. You want to be as transparent, and consistent is another word that I'll use. Transparent and consistent with the candidates, so that they know what your process is. There's no uncertainty as to where they are in the process. There's no expectation that they're getting paid when they shouldn't have an expectation of getting paid. And they know when their clock to get paid starts. You're an employee as of this date, report at 8 in the morning, punch the clock, so to speak, and you're on the clock and you're an employee. So I mean, I think there's no legal mandate for it, but I would think that an offer should be in writing and accepted.
Yeah, I think that's a lot of what we'll talk about throughout this. Is the law can be vague, and sometimes it's vague for a reason, but there's definitely best practices to help you avoid something costly down the road. So they've now made the offer. The employee has received their conditional offer. Let's say they've either accepted it or they're in the process of accepting it, but you're still kind of in that interview process. What is now open to the employer to discuss with that individual now that conditional offer has been made? So, because you alluded to.
And again, this varies from state to state, but this would be the time when you would be able to, do your drug testing. This would be the time when you would be able to. And some states allow you to do it, pre-conditional offer, but for the most part, you would be doing your drug testing. You would be doing any fit for duty, pre-employment testing that you wouldn't normally be able to do for just any applicant, and anything else that the state law differentiates applicants and employee or conditional offer candidates. And there are some credit inquiries that you can do, particularly if someone's going to be handling money. And again, some state laws say you can never check credit. Some state laws say it's okay at the conditional offer stage. So again, your timing, I would have a tiered process, and your timing on those kinds of inquiries would be based on their status there.
Well, and kind of a big topic that at least comes up a lot in our industry, and we've talked about it a few times, and it sounds like it's probably more open following that conditional offer, again, depending on state law. But let's touch on fitness for duty for just a bit. We've had some high profile issues surrounding that, but it's part of the construction industry. These are physically demanding jobs, so there are certain requirements that are going to be placed on an individual performing the work of an electrician or a line worker, within our industry. So if you're telling an employer that is going to be performing fitness for duty, what's some of your advice on best practices they should follow?
Well, I'll start with consistency. So whatever test you employ should be employed consistently across the board. And now you can make some distinction in certain situations on gender, but you want to employ a consistent, test, because it has to be, the second prong that I'll bring up is it has to be based on a legitimate business reason. And so, there are ways to make sure that you have some peace of mind on whether or not your fit, I call it fit test, your fit for duty test, is validated in your industry. So, in the trades, you want to make sure that you're using a company, using a third party, vendor that has a test that is passed muster in the courts, and doesn't have, for example, 150-pound lifting requirement for a job that you can get away with 30 or 40 or 50 pounds, whatever the measure would be. And I'm not wedded to what the different industries use as measuring sticks, but you want to be consistent. You want to use a validated test, and make sure that it is backed with a legitimate reason for doing it. Because otherwise, if you don't have that, and you hire folks who clearly aren't ready, willing, and able to perform the essential functions of the job, then you're exposing you and the rest of your employees to liability, because you're going to have someone who can't get a certain aspect of the job done.
Yeah, term that you mentioned there that I kind of want to focus in on is the essential functions of the job. So that's something you should have in mind when you're implementing a fit for duty or a fitness test in any way. Is it has to be the essential functions of the job. Jeff threw out some numbers there for weight, and weight actually, or weight lifting, I should say, is what usually gets tested and validated, at least in our industry, because an employer may put in there, and I have seen 150 pounds that an individual has to lift, up past their waist or something like that, and then walk 50 to 100 feet. And whatever their reasons may be for doing that, but you really dig into it, and how often are you doing that? Is that even safe for an individual to be carrying that much weight on their own?
Right.
The answers are usually no. Usually over a certain weight, you're having a second individual help you carry it anyway, or there's some device or something to move the weight. So yeah, whenever you're looking through your fitness for duty policies and you're evaluating these, Jeff hit on some very good points there. The very first one, and I will just drive it back home, is consistency. The same, no matter who's applying for the job, they go through the same test. You can obviously have different tests for different jobs, but whoever's going for that job should get the same one. Again, the essential functions, it should apply to the job. And the last one is a really big one. It's kind of the arm's length. It is best to hire this one out. It's usually not recommended to be conducting something like that in-house. There are firms out there who this is what they do for a living. And you should, kind of keep that at arm's length. Kind of treat it almost like drug testing. You're getting back a fit, unfit, or fit with accommodation, so to speak. So yeah, Jeff, I appreciate that. That's a big one for our employers. So we talked a little bit about best practices, as employers are moving through the kind of that pre-employment process. But How important is it as an employer is working through this process to document their decisions, whether to hire or not hire an individual?
Well, I mean, it's critically important because I mentioned earlier that you should have a recruitment interview policy. You should script the questions that are going to be asked of each candidate. They should all be the same, and they should all be asked. And then you should take notes and document the process, because what's going to happen is if that candidate doesn't get the job and sues you, then it becomes well, this is what you said, this is what I said, you asked me these inappropriate questions, you told me I had to do this and that's illegal. And if you don't have that file, then you're in trouble. The other thing that I'll tell you about note taking is don't write anything on a piece of paper that you wouldn't want your grandmother or a judge or a juror to see, right? So I've been involved in cases with clients when I was in private practice where, you'll read things in an HR recruitment file like, this guy's never going to get, I'm never hiring this guy will never get this job, this guy's a clown, just ridiculous things that, because it's made a part of the record, gets discovered later on. So no doodling, no annotations, the questions, anything that's relevant that needs to be associated with that interview process should be documented, should be available for the employer's use down the road for protection.
Yeah. And then that's, I'm glad you went that direction. That's what I was trying to draw out there is the documentation, like you said, is for protection. And we deal with this beyond just the hiring process. We deal with it in grievances as they come up. And I can't stress it enough to employers is document. It's so difficult to defend someone when it is a he said, she said type situation. So whenever you have that documentation, when you can back up what you say happened, it makes things that much easier and that much less liability on the employer. And I would think that's one of our goals here is to lessen said liability. So kind of moving through this, the hiring process, one that's definitely come into the mainstream here, and we're seeing it a lot, especially with these large projects. And I mean, it's not new, but we're seeing it pop up more, would be background checks. The first thing I'd ask is, or I'd ask of you on this one, Jeff, is from a legal perspective, what boundaries exist for an employer performing a background check on an individual?
Yeah, I mean, you have to be very careful, and this is one of the areas, and I don't mean to cop out here, but state law, this is very state law driven. There are things that you can do at the conditional offer stage that you can't do at the interview stage, at the pre-conditional offer stage. You can ask about certain crimes depending on the state, felonies and violent crimes and crimes that involve dishonesty and unethical behavior. There are certain states that will practice what they call ban the box, so that you can't ask about prior convictions that aren't relevant to the job because that has a disparate impact and has been found to have a disparate impact on certain folks. And so the first thing that I would do is if you're going to do a background check on someone, consult state law and make sure that you're not inquiring on areas that you can't inquire on. I wouldn't do the background check myself if I was an employer. Again, I would go get a third party that knows what inquiries can be made and what inquiries can't be made. Because again, if you disqualify someone for for an illegal reason, then you're exposing yourself to liability.
Yeah, great words there. I'd say you can almost kind of align background checks a little bit, even with fit for duty. Like you said, you want to keep it arm's length, and it's very state law dependent. And frankly, I don't consider that a cop out, Jeff. I mean, that's just good advice for any of our employers or managers. Is the U.S., the way we're set up is that each state kind of has their own little way of doing things. So you can take our advice as general and as best practice and as a start, but you should always, engage local counsel, somebody that is an expert of your particular state law, as background checks can be a divisive one, and that can vary wildly from one state to another. So stepping still into this process, so we've done background checks, we've done fitness for duty evaluations on an individual, and we're kind of asking them some questions during the interview, trying to get to know them. Are they a fit for the job? Are they going to be good with the company's culture? And like you said, you want to be consistent. So if you're trying to bring on somebody for a particular position, you want to make sure you ask all of the same questions. And this is one we get a lot in the apprenticeship. We actually have standard questions that we use across the country. But employers always ask is, can I ask something else? Can I add a question?
Sure.
What do you think?
So, I would be very careful about that. Now, if you have an area that you're just adamant that you want to get into, again, I would script it, and I would make sure that everyone gets asked the same questions, and I would make sure that those questions are okay under state and federal law. So, one of my favorite pieces of advice for folks doing interviews or in the recruitment process is to just Google in your state proper employment recruiting questions and improper questions. And usually you're going to get some kind of chart that says, here's what you can ask related to age, here's what you can't ask. Here's what you can ask related to disability, here's what you can't ask. Here's what you can ask related to, family and marital status, here's what you can't ask. And you'd be very surprised about the questions that you can't ask. For example, the only question you can ask about age is, are you 18 and can you take this job? You can't ask somebody's birth date. You can't ask, all that'll come out later when they're filling out their tax paperwork and all that stuff, but you can't ask their birth date. You can't ask what year they were born. You can't ask where someone was born. Okay, you can ask if they're authorized to work in the United States, but you can't ask if they were born in America or if they were born somewhere else. You can't ask anything about color or race. You can't ask anything about gender preferences. You can't ask anything about, you can't ask much about disability. You can ask if they are qualified, in their opinion, to perform the essential functions of the job. You can't ask if they filed claims for workers' comp at their old job. There's just a lot of stuff that folks want to get close to that line. Well, I want to know if they're chronic complainers, so I want to know if they've ever sued a prior employer. You can't ask those questions. So, I would get a chart, and if you're adamant that you want to ask questions in a certain area, I would make sure that those questions are legal and ask them the right way. Otherwise, you're going to run into trouble. You're going to get a complaint from someone who didn't get a job because they think you asked them an improper question.
Staying on the questions, going to ask you another question.
Sure.
So we're in the interview process, and you're going through your standard questions. You made sure they're all legal. But the individual volunteers some information. Are you allowed to then ask them to elaborate on said information?
I would almost ignore that question, and I would I've been in that situation, and what I would advise is that you say, that's not an area of inquiry for me, and so I'm just going to leave it. Like if they say, well, I want you to know that I'm married and I have 3 kids and family's very important to me. You can say, that's wonderful, let's move on. Because you don't want to say, well, how old are your kids? Do you have daycare obligations? Do you have to run your kid to school? Are you going to take off work because you have kids? Is your wife planning on getting pregnant, or is your husband planning on, doing X, Y, and Z? You don't. That's a slippery slope because you asked one wrong question, and now you've jumped into it, right? It doesn't really matter that they started the conversation. You don't want to finish the conversation.
Yeah. Very good advice. What can seem as just normal conversation could potentially come back to bite you later on. So yeah, Jeff's words are very much words to live by. Stick to your line of questioning. If the individual volunteers information, thank you, move on, kind of thing. Before we move out of the applicant stage, because we still have an individual that hasn't, been hired, do you have any kind of parting words for employers? So as they're conducting this process, anything maybe we haven't touched on that you wanted to throw in before we talk a little bit about an employee?
Yeah, I just think just go back and stress having a policy, making sure it's written down, making sure that the recruitment process is scripted and documented, and making sure that it is consistent with everyone that comes in the door.
Yeah. And then from a labor relations standpoint, I would just say make sure it's consistent with your CBA too.
Sure.
Because again, and we're about to talk a little bit about employees, but everything Jeff and I have just touched on here should theoretically exist before the collective bargaining agreement kicks in. We're talking about an individual who is an applicant. They are not an employee of the company yet. And as we say when we do classes or we talk about the collective bargaining agreement, it applies to employees of the company. It applies to bargain work, which requires compensation, therefore is an employee. So everything that's been kind of discussed up to this point exists prior to the CBA kicking in. Now, for those of you out there that are sticklers for detail, you're probably saying, well, we have substance abuse in our agreements. That is an area that officially NECA has agreed to bargain with the IBW over. And we have Category 1 language on substance abuse, but that's the only area where we recognize an applicant, if you will, in the agreement. Anything beyond that, as we consider it as the collective bargaining agreement doesn't apply. And a side note on substance abuse, if you didn't know, there is recommended language, not beyond the Category 1 language. There's policies that go with it. If you don't know what they are, you've never seen them, reach out to your field rep. Contractors, reach out to your chapter manager, and they know how to get a hold of it. But now, let's talk about two scenarios here. The first one may be the easiest one. So we've got an individual that's come in and they've applied for a job. They've gone through the full interview process, but unfortunately, it's just not going to work out. So, Jeff, what's the best way for an employer to communicate that to the individual?
Say, sorry, it's not going to work out. And then,
easy enough.
Invoke your right to reject and don't give a reason for it.
I don't want them to say any more than that. That is exactly what, exactly the advice to live by. You're not being hired because you're not being hired. And that's it.
And I'll liken it to how do you terminate someone that is an at-will employee? And I recognize that, our bargain folks are protected by the collective bargaining agreement, but if you have non-bargain folks and you're terminating them and they're at-will employees, the advice I always give is today's your last day at X company. Good luck in the future, and escort them to the door. And when they say why, the answer is today's your last day at X company. Good luck in the future. And it should be the same with your right to reject. It's you don't owe a reason unless you put that in your contract. For some reason, you don't owe a reason, and if you give a reason, then you got to defend that reason, and you don't need to put yourself in that position.
That one sentence Jeff said there, you have to defend that position. That is, I would say, 80% of the grievances that we get. It's an employer has made a decision to terminate, and then they go the step further and they provide a reason. And then that's what the entire agreement becomes focused on, is why. It's human nature. We want to answer when we're asked a question, but that is one where you have to kind of go against your instinct, and just the reason you're being terminated is you're being terminated. Today's your last day. And that does apply in our collective bargaining agreement, unless you have negotiated language, which I would say conflicts with Category 1 language, that requires you to give a reason. If you have strictly the Category 1 referral, you have the unfettered right to reject, and that's a right that didn't come easily and was negotiated in quite a long time ago, and employers should exercise that right whenever it's applicable. Piece of caution I would give with it is unfettered doesn't mean without liability. Be careful about establishing trends in your right to reject. One that employers get caught up in a lot is if you can look down a list of individuals that have been rejected and you've provided no reason, you just rejected them. But if a protected class or something can be determined in that list, then an argument can be made that that employer doesn't employ fill in the blank protected class of individual. Now you have a whole other issue on your hand. You've complied with the CBA, but you violated the law. So just one to be mindful there. So Jeff, we talked about that one didn't work out, but the next individual did. They're now an employee, so there are legal protections for an applicant. What legal protections does an employee have separate of a collective bargaining agreement?
Well, the collective bargaining agreement is going to provide most of the protections that that you would get under the law, just in a different form, right? So when you're an employee, you are then protected by things like the wage and hour laws in the United States. You're entitled to whatever workers' compensation protections and requirements are granted to employees and put upon employers. You are, then entitled to any of the protections that are in a handbook or any of the policies that an employer has related to employees. You don't see many policies, employer policies, handbook policies that are applicable to applicants. And you may have an applicant section in an employment handbook, but probably not. The first line of an employment handbook usually says, you are a blah, 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 blah employee of X company. Here's your policies and procedures. So once they're on the team, once they've gotten into the tent, then they're cloaked with all the laws, statutes, regulations, CBA provisions that apply to an employee. And so they are afforded those protections, and it's a serious obligation that you undertake. So I always say hire slow and fire fast. So you need to make sure that the folks that you hire are folks that you're willing to protect and willing to provide everything that you owe them.
Yeah, and we could get into a legal dissertation of the different acts and laws that apply to them, but then that would really only be from the national perspective, and then we're going to sound like broken records, but state law could be very different, whenever you're talking about employees. But Jeff's phrase there, hire slow and terminate fast, that's kind of words to remember and to live by as well. You should be very methodical in the interview and in the hiring process, but when it comes time to separate that employment, it's separate the employment, and that's where the period goes on that sentence. And just to kind of expand on it from a collective bargaining agreement standpoint, we operate under the management's rights clause in our agreements, which basically says the employer is free to conduct their job sites, conduct their business in any manner that doesn't conflict with the agreement. So long as there's not a provision in the agreement that says an employer cannot do something, by right they can. Obviously, there's a whole other discussion we can have on that. It should also go without saying, but I'll say it anyway. It should also apply to law, both federal and state law. Now, moving from there a little bit, Jeff, do you have anything on the employee handbook? So, because you brought it up a couple of times, or employment policies, anything you would recommend an employer either should absolutely be sure is in there, or I guess, and absolutely should be sure is not in there. So,
Well, first of all, in our world, you need to make sure that whatever policies you draft don't conflict with the collective bargaining agreement. Okay, and if your collective bargaining agreement, has Category 1 language in it, as it should, and has a good management rights policy, there are certain things that you're going to want to put into a handbook, into your policies, that will structure sort of those management rights a little bit, for lack of a better way to put it. For example, I think that it is important to have a safety policy in your policies and procedures, because safety is, as we're often reminded, the employer's responsibility, and so is the liability that's attendant to operating a safe workplace. The law places obligations on employers for safety. So you should have a safety policy that talks about, any kind of fleet management issues that might arise on the job. None of that's going to be covered by the collective bargaining agreement. And since it's your obligation as an employer, you ought to set out the rights and obligations on safety. You probably want to have a social media policy, right? So what folks can and can't do with regard to the use of the tools that you give them, via telephones and computers and things. The way that you safeguard the company's name, and how employees can and cannot hold themselves out as representing the company, keeping in mind their Section 7 rights, but also protecting the company from unwanted liability and exposure because someone's losing their mind on social media. So that would be something that you'd want to put into a handbook and policy. Other non-bargainable workplace type of roles that would be kind of tied to your management rights and maybe need to be spelled out in a handbook or a policy.
Yeah. Now, the employee handbook, employee policies, however you want to refer to it, is absolutely important. If you as a company do not have one, it's definitely something to look into. And then if you do have an employee handbook, and I am referring to a situation I was involved in at one point, and the last time you reviewed and or updated said handbook has 2 digits in the years, you definitely want to take a look at that again. Have legal counsel look at it. Have your chapter manager go through it if you're as an employer, because they're not going to be able to provide you a legal perspective on it, but they may dig something up that's, hey, this doesn't necessarily work well with this section of the collective bargaining agreement. We might want to tweak this to help avoid an issue down the road. So Jeff, thank you for that information. Well, Jeff, I appreciate you lending me your time today. I always
Sure.
throw it back to whenever you came on to NECA. I was kind of like a kid in the candy store. I had access to an attorney that I didn't have to worry about billing me at an hourly rate, and I'm going to continue to abuse that. But I do have to let you get to other things today. But before we do that, we've talked about quite a few things, and hopefully employers and chapter managers, anybody listening in, will be able to take away quite a bit on the hiring process and transitioning from an applicant to an employee. But in your opinion, if they had to bring away just some key items from what we've talked about today, what would you say this is an absolute must to remember?
Yeah, I mean, I just think that, hiring and recruitment is so important. We have the referral process, obviously, and there's a mechanism for that. But in the end, every employer is making the decision as to who to bring on to their shop. And I think that you need to have policies on recruitment and hiring, interview policies. They should be in writing. You should train the folks that are doing the intake for you. They should have a script. They should have objective criteria. They should document their process and make sure that everything that you do and as part of your policies apply consistently. And I think if you do those things, you will avoid claims later on, and you'll be able to hire the right people and not hire the people that don't pass muster.
All right. I think I'm just going to end it with one word: consistency. Just throughout the interview process, the hiring process, be consistent. And that has a lot of different connotations to it. But Jeff, thank you for your time. Viewers, listeners, we appreciate you guys tuning in. We're going to keep pushing more of these out. If you have any topic recommendations, if you want us to expand on any topic we've already touched on, please just let us know. Reach out to your chapter managers, contractors, chapter managers. Let your field reps know. They can pass the information on up to us. Also, if you have something you want to talk about and you'd be interested in joining us, it's pretty easy. Jeff can tell you that the onboarding process is relatively simple. Hair and makeup is, it's a breeze. But in all seriousness, thank you. Appreciate you being here today, Jeff.
Sure.
Thank you.
Happy to be here.
Listening.
Thanks, Ryan.
Yeah. Have a great day, everyone.